Gabe, how are you today? We don't have anything criminal on the docket
I
today.
know, but I need to heckle Rick at some point.
Where everybody knows, it's being live streamed, audio and video at this point, so.
Yeah, I figured you got to treat my work for so long. So. I know. Have you been? Good, good. Here, just watching the news on government shutdown. Gonna stay here with Pat Friday. So, yes, technically, I don't think new hires can start over the government shutdown. So, government shutdown, then maybe just stay here another week or two until they can figure it out. Yeah, he's like, Josh and Ryan are both praying for a shutdown to happen. Extended shutdown. Yeah. Shutting down. That around here. Like, I mean, I was just gonna my inline up there, so it's not like. Yeah. Nope. That's right, you're leaving us. You heard that, that's great. Oh, no, sorry. Yeah, that's great. Wow. Thanks for it. Yeah, I'm in West Virginia. So she was attorney's office doing, white collar. Pretty exciting. Get family in? Yeah, okay. Like, that's where all my wife's family's at. They're actually in Southeast Ohio. That close to West Virginia. So they're from my mother-in-law's house is a 3-minute drive to West Virginia. Oh my God. They're right on right there. Yeah. So it's an hour drive to their house. And, they're actually the closest family to the side here too. So we have no family anywhere near here. Yeah. Grandparents with the kids, the cousins around. All that. So when you're wrapping up this month? So my last day is supposed to be Friday. Okay. And I'm supposed to start up there on the 11th. But with the government deal, I'm just gonna. I know OPM hasn't given them guidance yet on exactly what they can and can't do. So wow. Because technically, criminal AUSAs are exempt from the furlough requirements because it's for protection of life and safety and crime. But you're technically not an employee until you start your first day of work. And it's all about laws, it's about lawyers. I'll be honest, I didn't read any of the briefing notes. Anything in your case. You didn't prepare? No. No, I did not. I watched one last year about there's a lot about the emergency service district in Huntsville and I actually talked to the lawyer who argued that afterwards for a while, but I spoke to all the lawyer. He's like, I think there's only 3 people in the entire state that would actually understand this. It's you. Yeah, it's actually kind of interesting. Yeah. Bradley. How you doing? Nice to meet you. And then Brandon Oaks. They're one with David Olson. Rick was the briefing attorney on the court for 12 years, 13 years?
Over 12 years, and then talking about.
Recently switched private practice like a month and a half ago. And now back in front of the court, he worked for
Are you new here? You're the new hire?
Yeah.
Very good. Very good.
I'm taking my dog and learning almost the 5 days. Yes.
I can see that.
You're gonna handle Marshall Shrek. Oh, I haven't mentioned it. Wanda died. I think Wanda died. Really? Yeah, so she passed away. Yeah, she was playing, and so she died, but I haven't heard anything. Last I heard, like, she came up wanting something from John, and so Windsor's having issues. The Supreme Court has petitioned to remove the injunction. And then somehow his own personal injury suit that he was drinking, he got hit by an 18-wheeler. The 11th Circuit was bill against him on that, probably from judges or something like that. Yeah, that's a long while ago. I haven't checked the water. Oh, I check his Facebook page occasionally, just 'cause I'm people. And so now he's just going through like 6 weeks of dental surgery, and he can't like move half of his body. And so, but his bar association he's created is not really taking off like, it's so bars. Well, it's the AANL, which kind of sounds like it, kind of just weird, but it's like the American Association of Non-Lawyers. Right. It's like, and he's trying to get Taylor Swift. Yeah. Dude's great. Kim Kardashian, I can't lawyer, right?
Her bar study aside, it's too much work. Yeah, she finished. No, she was struggling, she is a baby bar.
Yeah. She has a great bar in California, but yeah.
But she admitted this week she was struggling with the actual study in 2025.
Williams are, yeah, they had a little objection against him, kind of like the district court. Somewhere in Georgia, that bars have filing any lawsuit in any court in the country without permission of the federal. Because he is so crazy. Oh, I think I was thinking.
You were named too?
Yeah.
Yeah.
Maybe, no, Luke's wasn't on, Luke's on the one series. No, Brandon Luce was not involved. All right. Yeah. John gets told, Mickey Price. All, everybody. So I think the case against Menard is still pending. Because when he filed the name Menard, it's an automatic severance because he's in her court. And so we had to get that one severed out, and then it went to another judge who then, because you have to report it at this point. And so the AG's office called me, because the judge supposed to look at it, review it, find that it's frivolous or not, and it's bullshit. It's if that anything, be curious. Yeah, I think it's going to be that mom. What is crazy? Taxation.
No.
But I was never sure. Yeah. The whole federal court thing that. Yeah. It's our while. I was real happy. We network. Because of the injunction, because then the district court was. Because. And we were able to rely on tier four to say we're not. So because basically like. I don't know if we can really rely on the federal courts and. Yeah, the federal courts can't join state courts, but we can voluntarily comply with the federal injunction. And they're not joining state courts, they're only going to. That's. But I know Susan can have put in for it. Which might. I'd be okay with that. You've read the records, you know. Live, watching the live stream. Oh, yeah, it's great. Let me go back one. Like. The good thing is, like, I definitely like. After our, watch it, the next day, is like, sort of, okay, make sure I'm sitting on the station for stuff. And that's actually incredible. It is good. Yeah, I have the one in the spring board that are, the great fun one. Down, I want that to respond on the ground. Days. Not being the same. It only took over fucking room and then Ryan was there. They're trying to get one of them.
All right. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. Good morning. Welcome to oral arguments, 10th Court of Appeals, Waco, Texas, February 28th, 2024. We've got 4 cases set on today's docket. For planning purposes, cases 3 and 4 should know that cases 1 and 2 are going to be argued together. And so it will be a little quicker than noon on the 4th case. We do allow folks to move around the courtroom during oral arguments, do so with courtesy to the arguments in the court so that they're not disturbed or interrupted. As far as your cell phones, please check, make sure they are off or turned to the silent. I'll call the docket if are any exhibits or any other preliminary matters that we need to talk about before oral argument begins. Now is the time to do that. And I would like announcements of the attorney that is going to do the presentation and whether or not there are any preliminary matters and whether or not you're ready to proceed. First case is the state of Roger Lynn Ross, 1022-00038-CV.
George May for the appellant. Appellants.
Ready to proceed?
We are.
No preliminary matters?
We had originally filed our 2 appeals, as the board knows. We had originally filed a motion to consolidate those 2 appeals as we consolidated the argument here today. And the court, this was 2 years ago, denied that, and I'd like to move for the court to reconsider consolidating 2 appeals for consideration.
Okay, we'll carry that. Anything else?
Lawyer.
Your Honor, Rick Bradley, on behalf of Applee, Donna Ross, I have my co-counsel here, Brandon Oaks. I'll be doing the argument. We have no preliminary matters and we are ready to proceed.
Okay, thank you, counsel. The next case is actually we're going to take the Collingsworth versus Swallows as the next case on our docket.
Your Honor, David Pike, I'm the attorney that will be presenting for the appellants, Steve Harris and Nancy Collingsworth, who are ready to proceed and have no preliminary matters.
Okay, thank you, counsel.
Good morning, Your Honor. Patrick Krim. I will be arguing on behalf of the appellees, and I agree with opposing counsel. We don't have any other agreements or things to discuss. We're ready to proceed.
Okay. The estimated time on that will probably be starting somewhere around 11 o'clock. We may or may not take a break after the first and second cases before y'all. Third case we're going to take up will be Johnson versus Thornberry.
Good morning, Your Honor. I'm attorney Tyson Elam, and I'll be arguing for the appellant.
Juan McCollum for appellees, Jonathan Thornberry.
Thank you, counsel. Both ready, no preliminary matter.
Right.
Thank you. All right, counsel, you may proceed when ready.
Chief Justice, Justice Smith, Justice Johnson, may it please the court. My name is George May, and I represent two sets of two appellants in these two appeals. The first set are the daughters of the decedent Roger Lynn Ross. Roger Lynn Ross learned shortly before his he was actually shot by a neighbor in his driveway in the presence of his common law wife. But before his death, he learned that he had two adult daughters that he had been unaware of when he joined 23andMe.
Had he already submitted to 23andMe to make that determination?
If I heard the court correctly, Mr. Ross did submit his DNA to 23andMe and did get his report back and learned that he had two adult daughters who are the appellants in the first case, Ashley Settle and Victoria Morgan. Story was by Morgan. They did not unfortunately learn of each other and meet prior to his being murdered.
The reason for my question is you do have then a DNA from the deceased.
We do not have DNA from the deceased. The testing that was done, which was part of the evidence that was not admitted because the DNA testing lab, the National Screening Center, which is used by most family courts and several district attorneys, was not on file for 14 days required. It was filed as soon as was received, but the DNA test.
My question was not well framed. The DNA sample that was sent to 23andMe was from Mr. Ross and the daughters.
It was from the daughters and Mr. Ross's brother, surviving brother, and his sister.
Okay.
And a familial match was created. And I'll just jump right into it since this is what the court is interested in. The trial court struck the DNA evidence and the business records affidavit of the National Screening Center because it had not been on file long enough. Denied a motion to continue. And then in the motion for new trial, of course, the business records affidavit of the DNA testing center had been on file for 14 days. The missing evidence that was complained about by the common law wife, the appellee here today, was that as the court intimated, the test was a familial result, but we couldn't get a match to the decedent because we didn't have access to his DNA.
Let's jump to the issue, which is the failure to take the evidence up at a hearing after the will had been admitted to probate. Assuming that we agree with you that there would needed to be an evidentiary hearing, how do we structure the relief for remand?
The relief for remand, Your Honor, would be to grant the daughters a new trial with instructions to the court, or remand for a hearing on the motion for new trial, and the presentation of the new evidence subject to court student, was not heard, an objection to that, a continued objection to that evidence.
And as the trial court was asking, where does that get you?
Interestingly enough, the trial court, the daughters were not able to continue their contest of the will, the holographic will. So they did not have the opportunity to test the witnesses and participate in that trial. Their aunt and uncle, the brother and sister of the decedent.
So it would be your argument that you would have to set aside the existing order to probate and let them have their contest of the application of the will to probate. In other words, they get a do-over on what the brother and sister were unsuccessful in.
I'm not certain of that, Judge. That could be, if that is a proper remand, I think the proper remand for the daughters is to remand for a hearing on the motion for new trial. I'm not certain if the court can set aside the already adjudicated one bite at the apple judgment that the applicant got, because the daughters were not present in the court because they had been found to lack standing because the DNA evidence was considered. Now, the brother and sister in the second appeal, Beth and Brian, they contested it and filed the contest because their niece, their two nieces, had been kicked out by the trial court. They filed the contest themselves and did challenge. And that is really the crux of the issue.
Oh, let's go to that then.
In the contest where the appellant common law wife attempted to prove the holographic will, the requirement and the burden that she had was there had to be two witnesses who would attest to the testator, the decedent, handwriting. And at the trial and at the hearing, with a lot of help from the adline and help from the trial court, there were 0 witnesses that testified that the holographic will was the decedent's handwriting. There was one witness that did say, I'm familiar with his signature, and this handwriting looks like his signature, but she qualified her statement to say that I can't say for certain, and never testified that she was familiar with the handwriting of the decedent.
Well, they've changed their argument on appeal and said, well, we don't need to do that. There's the word may in the statute. And so we can use alternative methods of proving the handwriting of the testator. And so we can just do this, put on what evidence we put on, and the judge can make that call. How do you respond to that?
The judge, no, Your Honor, that may is not permissive. The may is laying forth how the procedure for proving a holographic. The only testimony we had in the trial court was the common law wife, the appellant, saying that's his signature. We have nothing else from anyone else, and saying that that is his signature does not vitiate the requirement, as the First Court of Appeals said in Lopez v. Hansen, which we briefed, as the Texas State Code said clearly in 256.154A. A will wholly in the handwriting of a testator is not self-proven by this title may be proved by 2 witnesses to the testator's handwriting. The statute has given us the means by which a holographic will can be proved, and there is no other method for doing that. Now, it's not wholly in the testator's handwriting, not wholly in Mr. Ross's handwriting.
We're gonna get around to that.
And that was my question. Do you keep using the phrase holographic will? Do you believe this is in fact a holographic will?
I do not. Assuming that this court agrees with the case law that says you can pluck out the handwritten portions and ignore the pre-printed form. And if the plucked out handwritten is sufficient to meet the test, if the court agrees with that, the language here doesn't work. I think we have in our brief, here is what the plucked out handwritten words are, and we don't know if they're in the testator's handwriting because no one ever testified to that. It says Roger Lynn Roth, decedent's name, Liberty Hill, Williamson, Donna H. Mulick, Liberty Hill, Doris Childs, Cedar Park, Texas. The total sum of my worldly property to go to Donna H. Mulick of 100 Riverview, Liberty Hill, R period, L period, R period, and then his signature. That is not sufficient to meet the test, and also the case law that says you can pluck out the handwritten words and ignore the printed words also say that you also have to look at the printed words to see if the plucked out handwritten words change the meaning, their meaning would be changed if you consider the pre-printed words. And yes, Robert.
What is the extent of the cases? What have they allowed to be plucked out or left on the page? My research indicated date and the notary's information. That was pretty much it. That you had to have basically a blank page, other than possibly the date, which, as an aside, rabbit trail probably. The date on the will was given as the date by the court of the date of the will.
With the date of the notary.
I couldn't tell if it was the date of the notary, but it was was it on the notary? Yes, would have been in the notary section.
Yes, 1998. It's not in the testator's handwriting. So what do we do to that? When was 1998 put in that?
And I'm more interested in, as Justice Smith alluded to, we're talking about there's a lot on this page that is, as a matter of law, is not in the testator's handwriting.
That's correct.
Pre-printed form, the title of the document, all of the discussion, if you will, about what they're doing, the appointment of a personal representative, even down to the line immediately before the larger part of the handwriting. I directed, after payment of all my debts, my property be bequeathed in the following manner. I mean, I'm thinking, what does the testator think is his will at the time he puts his signature on this document?
The testator thinks that it's the sum total of the entirety of the page, assuming that he actually executed this document and he actually filled out the handwriting, which we don't know because that was not put in evidence in the trial court below. All we have is a piece of paper that has pre-printed words, has handwritten words in one hand and in another hand, and testimony that that is his signature from one witness, the common law, the common law wife. I don't think.
Well, there was the CPA that testified that she was familiar with his handwriting and that she testified that she was familiar with his signature and she believed the signature on the will to be his.
Here's what the record at reporter's record at 28 says where testimony was. I probably have seen his handwriting on documents before. It almost looks like his signature. So I don't know that I can say that as a certainty, but it appears to be his handwriting.
But she had testified that she knew or was familiar with his signature and she thought the signature was his, as I recall.
Your Honor, counsel is unfamiliar with that. It's entirely possible if the record says that, it says that.
Okay.
So we have one.
But you're focused on the requirement of the case authority and the estates code that he has to have two witnesses that testify at the probate that the handwriting is the testator's handwriting.
And that is the test. That is what it has to be. And I don't know if this court wants to revisit its prior rulings on whether or not you can pluck out handwritten words of a holographic will, but we don't get there. Because the appellee did not meet her burden at trial, and the court should reverse and render that the will not be admitted.
Then what happens?
Then we remand for further proceedings in the probate to the application for heirship that was filed by both sets of appellants here. And if the daughters have the opportunity, they can prove up that they are in fact his daughters, which means that we not only have the separate estate from the inheritance that the decedent got from his late brother Troy to divvy up, we would then have an entirely different distribution because there were children outside of the marriage. So there are further proceedings to be had in the trial court.
What does that do to the daughter's appeal? What would we need to do with the daughter's appeal if the siblings' appeal results in a reverse render and remand?
Then the daughters would, and I think as a housekeeping matter, both parties before the court today agree that the striking and the dismissal on standing grounds shouldn't have been without prejudice.
Right.
So they can bring that again, but the motion for new trial, which should have been.
So we would have to address that in our judgment in the first appeal and the daughter's appeal. The fact that it wasn't with prejudice. We probably would need to do that. We're gonna have to do that, I think, anyway, because y'all agreed to that.
Yes.
The second issue. And so it's not, as we would say, the first appeal does not become entirely moot by whatever disposition is made in the second appeal, in the siblings appeal.
That's correct. You can tell the trial court they should have granted a new trial or should have heard and granted an evidentiary hearing for the daughters. And that it should have been without prejudice. So you can order the trial court to remand and order the trial court to hold that hearing so that they can prove their standing to either bring a contest or have an application to determine heirship. At the same time, in the second appeal, the siblings appeal, simply wasn't proven. The will should not have been admitted to probate, and the contest should have been successful. So the question, once everything is back down in the trial court, is can the daughters prove that they have standing? And the ad litem, by the way, the ad litem, I've been an ad litem, I know it's a very difficult job, did not know that he had other people to talk to besides the appellee's family. And the appellee actually originally filed an application to determine heirship and stated that she was the sole heir of the decedent's intestate estate. And only after the daughters came forward with their counter application for determination of heirship did this will suddenly appear. And moving back for a moment as to the date 1998, the genesis of that date and whether the court can consider it isn't as straightforward as the cases that allow that. Because what we have here is we have two daughters who were born before that date that the decedent did not know about. So that if we cannot determine the date that that will was, if it's any good at all, executed, and even if it stands up, then we have two potentially pretermitted children, which the trial court should examine, and that is another reason to remand for further proceedings. But in answer to the court's questions, since there weren't two witnesses to the handwriting, and I really even question whether there was one, the trial court determination was simply wrong. It should be reversed and rendered, and we should move both of these appeals back down to the trial court for the intestate succession application. Do you have any further questions?
Thank you, counsel. You may proceed when ready.
May it please the court, counsel. My name is Rick Bradley, and I'm here with my co-counsel Brandon Oates, and we represent Applee Donna Ross. I'd like to start my presentation with a point of emphasis. We've spoken quite a bit about the two appeals, and we're arguing them together, but we need to be very careful in how these have been briefed and how they were pled in the trial court. There were distinct and different things that were done by each set of parties that we need to keep in mind. And so we'll jump right into appellate cause number 22066, which is Beth and Royce's appeal. First of all, I want to make note of some procedural issues here. They filed their notice of appeal on March 14th, 2022. Yet they did not, they're challenging the trial court's February 1st, 2022 judgment. Clearly that was untimely. It was filed more than 30 days after the trial court's judgment. In addition, they have not cited to any kind of case law or any trap rule that would allow for the extension of the deadlines to 90 days or something of that nature. The timely filing of notice of appeal implicates this court's subject matter jurisdiction. And as a result, it can be raised for the first time on appeal and is never waived. And so I would argue to you that, first of all, as a procedural matter, Beth and Royce's appeal should be dismissed for warrant jurisdiction. We have a secondary issue with regard to jurisdiction, with regard to their judicial admission that they made in footnote 2, page 4, footnote 2, where they clearly and unequivocally said that they are not heirs under this will or in this proceeding, that they allege that Ashley and Victoria are. Beth and Royce are prohibited from taking inconsistent positions in a judicial proceeding. They're stopped from doing so. So as a result, this implicates their standing, and this is yet another subject matter jurisdiction issue for which their appeal should be dismissed.
Didn't your client take the position initially that there was no will at all?
That is, initially, yes, they did. But then once they found the will, they did file for an application for admission to probate. If this court can overcome these jurisdictional hurdles, then we move to the merits of the issue, which the court has been struggling with today. I will say that I don't want to rehash a lot what counsel has said, but I do want to point out a few things. The record shows that there were 3 witnesses that testified to Roger Ross's handwriting. It was Stephen Johnson, title attorney, many business transactions with Roger. He recognized his handwriting. We also have Stephanie.
Can you direct me to where he says that in the record?
Yes, sir.
That he's familiar with.
Yes, sir. Reporter's record 15. Stephen testified as to a deed of trust from Roger for the benefit of Millard and Francis Turner. He recognized the signature of the deed of trust on page 17 and said it was very distinctive. And
but that's the signature of Mr. Ross.
Understand.
On a document, not on the will.
Correct. But here's where the rub is. Beth and Royce did not file findings of fact and conclusions of law. And as a result, we must imply that the appellee gets to take advantage of the fact that all fact findings necessary to support the trial court's judgment are implied if they're supported by the evidence. In addition, the trial court's judgment must be affirmed if it can be upheld under any legal theory supported by the evidence. What we get at here is that the trial court can compare the signature on the bottom of the deed of trust that Stephen Johnson testified to the signature on the will, the holographic will, and make that conclusion himself, that this was the same signature. We have to remember too, that this was a legal sufficiency challenge that was made, as well as a factual sufficiency challenge that was made. And as a result, the trial court is empowered to make these inferences and these conclusions. But Stephen Johnson's testimony is not the only thing that we have in this record. We have Stephanie Arnold, who's a CPA who worked with Roger, did a bunch of bookkeeping and tax work for Roger and Donna over the years. And she recognized there was a financing agreement regarding a cabin. That's at Reporter's Record 24, where she talks about that. And his signature, she recognizes at 26. another instance where she recognizes the signature, the trial court can then compare that to the signature in the will and determine that this is the same handwriting. But that's not all. Stephanie also talks about the handwritten notes in the holographic will are very similar to Roger's signature on the document. That's Reporter's Record 28 through 29. And she said without a doubt that this was his handwriting, his signature. Now that said, on cross-examination, she did vacillate a little bit. And that's to be expected on vigorous cross-examination. But again, that's for the trial court to determine as far as a credibility and demeanor resolution of that evidence.
Counsel, the order that probated said the court heard testimony from two persons familiar with the decedent's handwriting.
Mhm.
But yet neither of these witnesses testified that they were familiar with his handwriting. They did talk about his signature, but not his handwriting, except that the CPA said that the handwriting on the document. In fact, the first witness was never shown the purported will. The second witness, the CPA, said, yeah, that the handwriting on the document that is purported to be the will is similar to the signature that she said she was familiar with, although she didn't say, neither of the witnesses said that the business records that were introduced, that they had seen the testator sign those documents. But my point is, the trial judge, the order says that there were two persons familiar with decedent's handwriting, but that's not borne out by the record. How do you get to use the inference in that situation? And that also, we have the additional question of whether or not you need the testimony of two witnesses familiar based upon the case law in the state's code.
Well, I would disagree with the characterization of the record that there is no evidence of his handwriting. One's signature is necessarily written by one's hand. It is in one's handwriting. And I think the trial court can make that inference and then as a result conclude that not only is the signature, but also the handwriting above the signature, directly above, and as well as his initials are in his handwriting. And in addition, there is a third witness, which is Donna Ross. She was asked herself too, whether this was the signature was in his handwriting, and she confirmed it as well. So I do think that that is a reasonable inference the trial court can make based on the evidence that's before it at the time. I'd like to move on to the next aspect, which is regard to the handwritten aspect of itself. Appellant's counsel has made the argument that this is not a holographic will because there's typewritten portion at the top. There's some fill in the blank handwriting at the top. And I would argue that the case law shows, and Watkins is going to be a very important case for y'all to take a look at. That is, let me find the site here. It's cited in, I know it's cited in appellant's brief. It's Watkins v. Boykin, 536 Southwest 2nd, 400. It's from the El Paso Court of Appeals in 1976. They concluded that if there a portion of the will that was admitted to probate is complete within itself, you can ignore all the recitals and everything else surrounding it, and it can be admitted to probate as a holographic will. What we have here is language, and the court's well aware of what the language is, and we've argued it in our brief. There's a clear intent on behalf of the decedent to bequeath property to Donna Ross. And he uses specific language that this court in Case and v. Taylor has also endorsed, which is the to go to or is to go to language, which indicates a future intent to convey or to bequeath property. But Watkins also says, and this is important, that the dominant purpose of a will is the disposition of property. The language at issue here is clearly a disposition of property from the decedent to Donna upon his death. And I think we also have to be real careful too in reviewing the record. The trial court, it bears out in the reporter's record, only admitted the little paragraph that we're talking about here, and that's the language where the total sum of my worldly property is to go to Donna H. Uke, I believe, that's Donna Ross, of 100 Riverview, Liberty Hill. Did not admit the other aspects on the page. And that's okay, because we look at Mulvey Williams, which is a 1934 commission appeal, and it said that the handwritten and printed recitals at the top of the will can be excluded or ignored if they're not necessary to complete the instrument and they do not affect the meaning of the will. And I go back to that language. That was clearly an intent to distribute his property upon his death. The recitals at the top had nothing to do with this dispensation of his property.
Did he think that they were part of his will?
Pardon me?
Did he think that they were part of his will?
I can't speak to that.
I mean, when you look at the document that is admitted to probate, there's a lot on there that's it's a pre-printed form, obviously.
Correct.
And when the statute says it has to be wholly in the handwriting of the decedent to be admitted as a holographic will, and then how does that ever cover this document?
Because again, we go to the primary purpose under Watkins of a will. It is the
So you could take a carefully drafted 30, 40-page will. Testator could go back, write in one line at the bottom of the will that says all to mom and signs it. And you would ignore the entire document, the 20 or 30 pages of a carefully drawn probate estate.
Well, we have to be careful. That is possible, but we have to be careful because it has to include specific words that dispose of property. I bring that up is because the Scott v. Schwartz case, which is 469 Southwest 2nd 587, and that one's out of the San Antonio Court of Appeals. They held that when you adding language, adding fiance and adding equal shares to a will, did not dispose of any property and therefore could not be admitted as a holographic will. So it depends on how that wording is done. If it is a clear intent on the testator to convey property at a future time or bequeath property at a future time, then I would argue it is possible. More facts may need to be developed, and I don't want to definitively say in all aspects that would be the case, but it is possible. We've addressed the specific language in our brief. We stand on that brief, in our brief with regard to that. I would like y'all to take a look at, or I'd recommend to y'all's reading the Cason v. Taylor case. It's precedent from this court. It has very similar language in this court. And I'll read the language actually. It says, "Dear children, I want my house in Irving to go to Earl. I want my car to go to Earl. I want my house in Meridian to go to Linda. I want the lake property to go to Lenny. I want the rest of my estate divided equally between Linda Carroll and Earl." Signed, Betty Ingram. That was the extent of it. And this court held that the language "to go to" indicated a future intent to bequeath property to somebody, to another, and found that the evidence was legally and factually sufficient to support the admission of the will as a holographic will. Ayala v.
Did
Martinez.
you say that was Cason versus Taylor?
Cason v. Taylor.
I only have an excerpt, don't have the whole thing in front of me, but that is one of the cases in which we said, and the focus in that case, based on this excerpt, is about where the initials can be a signature, but it also says if self-proved, if not self-proved, a will wholly in the handwriting of the testator may be proved by two witnesses to the handwriting, which evidence may be sworn testimony or affidavit taken in open court. So, and maybe I've got my authority mixed up. Was this not the one that had the printed name of one of the beneficiaries and wound up in a remand?
No, it was an affirmance. I do not believe it was a remand. And this court specifically found that the evidence was sufficient to admit all of the handwritten portion to probate as a holographic will.
I mean, because in looking at the facts of Gwynn versus Phillips, interesting, there was a bank employee, somewhat like the CPA, had very similar testimony to this. And I was thinking, okay, I'm sorry, it's Gwynn v. Phillips that, they couldn't testify that N.L. Phillips was in the handwriting of the testator. And it was a court that really focused on the requirement of the proof of that there be evidence about the handwriting, because it was a question of whether or not that name was in the handwriting of the testator. And so,
but we have evidence here. We have Stephen Johnson's testimony. We have Stephanie Arnold's testimony regarding signatures and Stephanie Arnold's testimony as to handwriting. And we have Donna Ross. We have evidence as to that. It's not that we have nothing. So I find that to be our case to be factually distinguishable from that case that you're speaking of.
okay.
I'd like to make another point here, moving on to Victoria and Ashley's appeal in 038. We need to be very careful once again to make sure that we review the record closely and determine who filed what and when it was filed. Ashley and Victoria, you can see in their briefing, have not challenged the probate of the will. Only Beth and Royce have. I do not believe the law provides for Victoria and Ashley to piggyback off of Beth and Royce and challenge the probate of the will. That's important because by failing to challenge the probate of the will, that moots their argument with regard to the motion for new trial.
But the court said they had no standing.
Correct.
So that they're out. I mean, how do they come in on a ruling and challenge a ruling that the court didn't let them participate in the hearing that resulted in that hearing?
Well, they haven't challenged can you rephrase your question? I'm sorry.
As I understand their complaint is we had the right to participate in the hearing that resulted in the probate of the will. But you kicked us out ahead of time. You didn't let us have an evidentiary hearing on whether or not we should, in motion for rehearing, whether or not we should be allowed to participate in that. And so it seems like if they win their appeal, they would get the chance to go back and challenge the hearing that you didn't let them participate in.
Well, let me step back and make one additional procedural argument before I address the substance of what you're speaking of. The record will show, and perhaps this is a clerk's record issue. It's admittedly messy. From my understanding, there were some issues with the clerk's office in Falls County. But we see that the motion in limine, which dismissed Victoria and Ashley, which was really a motion to dismiss, was granted on November 11th, 2021. They've not filed a motion for new trial. It doesn't contain a file stamp until December 31st, 2021. So on its face, it's untimely. So we have that aspect that might need to be explored. I'll leave that to the court's discretion on how that shakes out. But Section 202.002 of the Estates Code states that heirship proceedings are only appropriate when the decedent died without a will, it is necessary for the administration of the estate, or the will did not dispose of all assets. What they're trying to do is revive an heirship proceeding after the trial court determined that there was a will. And they can't do that. And so their argument is moot at this point. And so that's all I can respond to this unique situation, fact scenario.
Does that analysis change if we decide there wasn't a will?
If you decide there was not a will, then perhaps yes. Perhaps yes. Because then the probate then cut off their rights in the heirship proceeding, to be candid. The third issue, I want to touch on that real quick. I don't know how much time I have. The timer's not.
Yeah, I should have checked that. They move the lectern and occasionally it unplugs, so.
Okay, well, I hope I'm not going over my time here.
You actually are. You're at 28 seconds over.
My apologies, judges. With your permission, I'd like to just touch on real quick Ashley and Victoria's third issue and wrap up, if that's okay. Okay.
Wait, I'm gonna hit a button here and you're gonna amazingly have more time. You should have a minute.
I see nothing.
Oh, it went away again. Your tax dollars at work.
Okay, here we go. All right,
There
great,
you go.
fantastic. Okay. Regarding the third issue, Ashley and Victoria have complained about the lack of findings of fact and conclusions of law. I just wanted to restate real quick what we said in the brief. They don't have to guess why they were kicked out of court. They lack standing. It's clear in the order. It's clear in the motion that was filed. It's clear. And in that regard, there is no harm because they don't have to guess and they can easily present their case to the Court of Appeals on that issue. So to wrap up, what the appellate requests is that first, Beth and Royce's appeal is dismissed for want of jurisdiction, or in the alternative of all their issues overruled in the case of the family. And with regard to Ashley and Victoria, we respectfully request that that the court dismisses their first and third issues and sustain the second issue. And as a result, it would be a modification of that trial court's order saying that they are dismissed without prejudice.
Okay.
And with that, any other questions? Thank you very much.
Thanks, counsel. You have 5 minutes to rebuttal.
Appellate counsel thinks the court, from its questions, pretty much has the case on ice and knows all of the issues and facts. I would point out that, both appeals were timely filed. There was a motion for a new trial, and if the Falls County Clerk's record shows different stamps in some recreated record, counsel would like the opportunity to examine that record before there's any question about timeliness. The fact that inferences are allowed from a trial court's judgment doesn't change the fact, as Chief Justice Gray noted. The trial court specifically stated in its order why that there were 2 witnesses to the handwriting. Record does not show that. That is unsupported. That is a reason to.
What do you think about his argument that the testimony is that they're familiar with the signature and so they can back out, and that is in effect allows an inference as to the handwriting on the book?
That is a creative and aggressive argument, but the estate code makes clear distinction between handwriting and signature. That's the law that has that prior rulings to this court. Signatures are not handwriting. Signatures are a different and unique thing. One thing that we didn't touch on that was talked about is, well, talk about the lack of findings of fact and conclusions of law in the daughter's appeal. It is presumed harmful unless the face of the record shows that there was no harm by not having findings of fact and conclusions of law. It was dismissed on standing, but in order to find that standing, we needed to know what the court allowed, didn't allow, and found. Did the court find that the evidence was insufficient? We don't know what they found. We don't know what they concluded to not allow a determination of heirship and a right to challenge the contest. All the court said is, you don't have standing, did not say why. That is the missing link, and that is what is necessary for the daughters to be able to effectuate and protect their rights. Court has no further questions. I think we're done.
Anything else?
No, sir.
Anything else? Okay, thank you, counsel. These cases, both of them are submitted and y'all are excused, although we've got another couple of state cases. If that's your cup of tea, you know, what's saying.
Thank you, judges.
Thank you.
Thank you. I don't mind.
Counsel, y'all can come on up to the table.
Which case, we've already.
We're fixing to argue yours, or as in, we say in Texas, y'all.
Y'all.
Do you have lights on your side?
It did for a minute, now it's not. Now it's back.
Is it back?
It is.
All right. Open, but I won't argue this one.
I was using
All right, this case is Collingsworth versus Swalls, 10-23-00018-CV. Counsel presenting is David Pike, and you may proceed when ready.
Thank you, Chief Justice. Justices, thank you for your time this morning to address the issue before the court, which is there something unique about wills that prevents an arbitration clause in a will from being enforced? I think I want to begin by looking at the enabling statute for arbitration, which is the Texas Arbitration Act, found in Chapter 171 of the Civil Practice and Remedies Code. It says that arbitration agreements are valid and enforceable, and that is the public policy of the state is so well known to the courts that I'm not going to go through a line of cases that say how favored arbitration is and how arbitration agreements should be enforced. There are 5 explicit exceptions to that statement that arbitration agreements are valid and enforceable in the Texas Arbitration Act, none of which apply in the situation. They have not been argued by the appellees either in the trial court or in this court that this is an exception that a will containing an arbitration agreement be unenforceable. So it is not in the specific language of the Texas Arbitration Act that says wills cannot have an arbitration clause. So with that general public policy in the statement from the legislature, I think we have determined that this is an agreement that can include an arbitration agreement. Arbitration is to be ordered if 2 things are found. 1, there is an agreement to arbitrate, and secondly, the dispute is within the scope of the arbitration clause. The arbitration clause here clearly says any dispute concerning the will is to be arbitrated.
Counsel, do you view the within the arbitration clause to include the definition of the parties as the appellee has argued in this case, is that they are not one of the parties, or is that a third factor, if you will? Do you understand my question?
I think,
Is the scope of the parties part of the scope of the dispute within the arbitration, Or is it two separate issues?
I think they're separate issues. I think
Okay.
because if there is an arbitration agreement, and as I get to using the term agreement, the Supreme Court has said that's in effect a relationship. And there's a relationship and the dispute relates to the relationship. That's the scope of the determination.
Okay.
Okay, now their argument in the trial court found that they weren't one of the parties listed in the arbitration agreement because they were suing derivatively. I believe that's a subterfuge. I don't think they really are suing derivatively, but I think it's easier to analyze than that. Because what does it mean to sue derivatively? They say they're suing derivatively in the name of the trustee. The trustees are specifically named parties that the arbitration agreement covers. So if they're suing derivatively for the trustees, as in any derivative action, you step in the shoes of the derivative party and you are trying to assert the rights of those parties. And of course, you're subject to the defenses and arguments that could be raised against those parties, regardless of what kind of derivative lawsuit is involved. This specifically came up in the Labatt case, the Texas Supreme Court decision, where it was a wrongful death action. Facts are rather complex. And as a probate attorney, not a personal injury attorney, I don't quite understand the wrongful death arguments, but I understand them as they relate to this case. In Labatt, the company had an alternative workers' compensation plan. And the alternative workers' compensation plan, they were a non-subscriber, the company. And so the employees had the right to elect in or out of this plan. The plan contained an arbitration clause. The employee at issue elected into the plan. The employee subsequently died, allegedly at the fault of Labatt, and causes of action were brought by his survivors. Long discussion occurs in the court's opinion. That is beyond my expertise. But the conclusion is they were suing derivatively. The wrongful death claims are derivative of the decedent's claims. And the decedent was bound by the arbitration agreement. Therefore, the wrongful death action should have been ordered to be arbitrated. So in effect, the Supreme Court has specifically dealt with an issue. If you are suing derivatively, you're going to be bound by the derivative party's agreement. And this clearly includes the party here. But I think the real test, as is referred to in the Rachel case or the Rochelle case from the Texas Supreme Court, the trust case that both parties signed in their briefs. And y'all can tell me how to pronounce that. Your guess is as good as mine.
I focused on the appellee's name and I couldn't pronounce it.
Fair enough.
Counsel, if you want to know, is Ed Rochelle, and the reason I know is because one of the trustees is, late trustees is a former friend of mine.
Well, now I am ratified and I was close. It's Rochelle. Rochelle, in that opinion, the court said, in looking at the Texas Arbitration Act, the act uses the term agreement, not contract. And agreement, it defines as, first of all, that is a broader situation than a contract. In other words, all contracts are agreements, but not all agreements are contracts. It is mutually, basically an agreement they defined as a mutual assent or two or more persons. This is in effect saying that there's a relationship and an agreement that's going to cover the relationship. So in a trust, as was the case in Rochelle, was that the settlor created the trust and subsequent beneficiaries to the trust, who of course had never signed the trust agreement, were bound by the arbitration agreement in the trust. Why? Because they were only bound together, the trustee and the beneficiaries. They only had a legal relationship to each other because of the trust. Likewise, with a will, we have a testator who creates a will, and in fact creates a decedent's estate, and he names an executor like a trustee and beneficiaries, and they are related to each other only through this instrument, the will. And therefore there is this relationship and agreement. In this case, the agreement says, if you are dealing with the will, you are going to be bound by the will's terms of an arbitration agreement. Testator was very expansive and very clear of wanting all disputes concerning the will. So what's the dispute here? It's a will interpretation, a will construction case. So we're directly dealing with what does the will say? And the argument is made, but we didn't sign that agreement. That's the exact argument that the Texas Supreme Court rejected in Rochelle. And it wasn't the first time the Texas Supreme Court has rejected that type of argument. The other cases we cited in the brief, the Halliburton case, these are all Texas Supreme Court cases. The Halliburton case involved at-will employment, where Halliburton modified its employee policy manual. Of course, the policy manual gives employees rights, vacation, disability issues, all sorts of things that companies put in their policy manual that are binding on the company. And they amended it to say, and any dispute is about the employment is going to be arbitrated. The employee was an employee before the policy changed, but continued employment afterwards. And the court said the relationship was that of the employment. And by continuing employment, it was not necessary for the employee to sign the policy manual or acknowledge an arbitration agreement. They, by continuing employment, continued in that relationship and agreed to the terms of the relationship. Likewise, there was the Taylor Morrison and Weekly Holmes case out of the Texas Supreme Court, where facts are different, but they have this commonality. They're construction agreements. And individuals are attempting to sue the construction company, the home builder, for faulty construction they allege caused them damage. And in both cases, they're saying, we're not a party to the contract. It was another family member actually contracted for the building of the house. And the Supreme Court said the fact of occupying the property means that you've considered to the terms of the relationship. In other words, the only relationship and the only grounds that the injured parties, alleged injured parties, had to bring an action against the home builder was because of the relationship of the home builder and the original contracting party. And by living in that house and trying to enforce the terms of that relationship, good and workmanlike construction that's implied in any construction contract, they are bound by the terms of the arbitration agreement. So what is not, it is not required that a party actually consent to the arbitration itself. It's not necessary that the party actually sign an arbitration agreement. What's necessary is that the parties, if they are bound in a relationship and agreement, and the agreement contains an arbitration clause, the agreement is binding on them. Final case I address in this regard comes out of this court long before your justice's terms, back in 1992, Merrill Lynch versus Eddings, a trust case where the trustee hired Merrill Lynch to do investment advisory services. Of course, it had an arbitration clause, but it was the beneficiaries who sought to sue Merrill Lynch. They were trying to say Merrill Lynch improperly exercised its duties under the investment agreement. And they said the benefit, this court then said, those beneficiaries are bound by that arbitration agreement because in effect, they're trying to enforce the rights and remedies under the investment agreement and therefore are going to be bound by it. If you conclude that there is an arbitration agreement and that there is a dispute within the arbitration agreement, which I think it clearly is, and then we get to the issues that have been brought up in defense.
Well, they do take the position that this dispute is not part of within the scope because it is they don't, as they say, they don't need the will. They just get what's left when the extent of the power of appointment is determined. So before you go on to your next point, can you hit on that?
Absolutely. This proceeding began with my clients filing a declaratory judgment action for the interpretation of the will. The appellees counterclaim, they called it a petition, but it was a counterclaim seeking interpretation of the will. So they put this directly in issue. Their pleading state that they need, quote, a declaration which requires the construction of the decedent's will. And the appellees are beneficiaries of the will. They both receive a cash bequest and personal property. They are bound to this relationship. And then they come into court and say, we want damages of at least $1 million because we want an interpretation of the will that enhances our gifts under the trust. So if they didn't contest my client's interpretation of the will, they would get less. They want an interpretation that enhances their gifts. But they have not taken any action to say, well, we're not beneficiaries of the will. They are beneficiaries of the will. The question is, what is the size of the transfer from the estate of assets and the size of the assets that are already in the trust that are going to go to the appellees or not? So I think it is disingenuous to say that they, first of all, did not seek a relief that related to the will and that they could ignore the will. The trust, of course, authorizes a power of appointment and requires it to be exercised in a will. So they're inextricably linked. The appellees, originally this action was filed in district court. And the appellees asked that it be transferred to the court exercising probate jurisdiction in Ellis County, being Ellis County Court Law Number 1, because they argued that this is a probate matter. And the court below, the district court, transferred this, and actually it was a joint order between the district and the county court, as those judges often do. And they said, we find this is a matter concerning the estate, and therefore they transferred it to the probate court. So on one hand, they said, yes, it's a probate matter. We want interpretation of the will. We want it to be handled by a probate court, but now want to say, well, we really have nothing to do with the will. That's just inconsistent with the record. So their other argument that we've largely addressed is, are they a party to the agreement? I would just go into a little bit more depth in that. If you don't agree that they are bound to the arbitration clause because they're suing derivatively for the trustee, the claim that they're suing derivatively is really subterfuge. They did not initially sue in the capacity of derivatives. They said they sued in their own capacity, seeking declaration concerning the construction of the will, which they're entitled to do as beneficiaries of the will. They have standing on their own. There's no reason they can't bring their own action, and they did. They also filed 2 other petitions seeking an accounting and seeking to remove the trustees. They did all of those in their individual capacity. After a motion to refer the matter to arbitration was filed, they admitted only one of those pleadings, the pleading seeking a declaratory judgment saying, but we're seeking this derivatively and we're not a party to the arbitration clause as a result. You can bring a derivative lawsuit when the derivative party is not bringing the lawsuit. The derivative party, my clients, the trustees, initiated the lawsuit on that very issue, the construction of this power of appointment provision in the will. So the whole we're not parties is a subterfuge, but I think it's easier to analyze to say, well, we'll take you at your word. If you're suing derivatively, you step in the shoes of the trustees and be bound. The final argument is that the structure of the estates code somehow prevents arbitration. In other words, you can't have an arbitration clause in a will because it would oust the trial court, the court exercising probate jurisdiction over the case. Well, that's not what happens in arbitration, regardless of the arbitration. In fact, most arbitrations begin with a party filing a lawsuit, and then one party or the other moves to compel arbitration. When arbitration is compelled, the case is not dismissed, the case is stayed. The trial court maintains jurisdiction. Once the arbitration is completed and an award is entered, what happens? You return to the court, unstay the case, and usually confirm the award and enter a judgment, because only a court can enforce judgments. And we cite a variety of circumstances in our brief. While even if a court is granted exclusive jurisdiction of the matter, eviction proceedings for a justice court, modifications of child support matters for family courts, those disputes can be arbitrated because the Texas Arbitration Act says that they can. The courts don't lose jurisdiction in those matters because the ultimate judgment and order, like an order of eviction, the order to the sheriff to give possession to the party seeking possession, has got to come from a judge. It's got to come from someone with judicial authority, and arbitrators don't have judicial authority. It's an alternative means of resolution to resolve disputes. So in this case, or any case concerning a will, we can refer an issue to an arbitrator to decide, is a will valid? Is a holographic will wholly in the testator's handwriting? And having that issue determined factually, the matter would come back to the court exercising probate jurisdiction to in fact enter an order. So there's nothing in the structure of the Texas Arbitration Act that's in conflict with the Estates Code. The Estates Code never says that that matters can't be arbitrated. And in the Center Point case from the Texas Supreme Court said there's nothing unique about probate courts, that they don't have some super jurisdiction that trumps other courts' jurisdiction. Your Honor, I have a little bit of time left, but I've addressed the issues I want to
What was that
address.
last case that you mentioned that said nothing unique about the probate code?
Center Point, Supreme Court 2021 case, 629 Southwest 3rd, 149.
Or you mentioned a while ago, an accounting, I think you said something about a distribution, then there's the interpretation of the will. But at this point, the only issue that looked like it was going to arbitration was the interpretation of the will. Are there other issues in dispute between these parties?
If all of the issues concerning the will could be arbitrated. So if this matter were referred to arbitration, any issue could be brought to the arbitrator at that time. I think that is the only live issue, because it's a threshold issue of do they have any rights as a trustee, vis-a-vis the trust. Did the power of appointment remove them as beneficiaries of the trust is a threshold issue. If they're not, then they can't enforce the trust, so they can't seek an accounting of the trust. So it is the threshold issue, which is why it was the focus, Chief Justice.
Are there other issues inside the will, and there other things that they're getting under the will or whatever that are in dispute? I'm assuming that
I
this is,
believe there will be, and I don't mean to be cagey, but they haven't actually been pled, and I don't want to give my able opponent ideas.
okay,
But I kind of think that when we get down to the link log, as we say, that there's going to be more than just if they have rights concerning the.
I mean, because you mentioned an accounting already, but that's the accounting of the
Trust.
survivors trust.
Both the survivors and a bypass trust.
Okay.
The revocable living trust split into those two.
For some reason, I was thinking the issues on the bypass trust had been resolved.
They have not.
Okay. All right.
Thank you, Your Honor.
Thank you, counsel. Is Counsel Patrick Krim in case number 10-23-000-18 CV. Counsel, you may proceed when ready.
Thank you, Chief Justice. Good morning, and may it please the court. I was not planning on starting with this, because candidly, we barely touched on it in our brief. You only alluded to it, but some things that Mr. Pike said makes me think that this is of primary importance, and so I wanted to lead off with it. Although the focus of this case thus far has been on the will and an interpretation of the will, I think there are two lenses that this court can view the case through in coming to its analysis. And frankly, the one I'm about to discuss might be the correct one. If we take a step back just for a moment, Even though this case has been characterized as a will construction case, as Mr. Pike recognized, it started in the district court because this case involved a trust. And it would be our contention that this is a trust case that just involves a will construction. It's not on its face just a will construction. And the reason why that is important, Your Honors, is that what the parties are fighting about are trust assets, not probate assets. Nothing disposed of by the will that's a probate asset is in dispute. And so the trust assets that we're fighting about, the rights to those assets are created by the trust, and the rules governing them are governed by the trust. And that trust, when it was created in 2011 by the decedent and his wife, they didn't include an arbitration provision. Their intent was not to arbitrate any disputes. And when the decedent's wife passed away in 2012, that trust became irrevocable and not subject to amendment. The only thing that was really left in flux was a possible disposition, alternate disposition of the trust assets that could have been accomplished by a power of attorney a power of appointment. And the settlors decided in the trust to make that power of appointment accomplishable in a will. They don't care about anything else in the will, just whether or not it accomplishes and carries out the power of appointment. And so when courts are trying to figure out whether a power of appointment created under a trust has been effectuated, the starting point is looking at the trust, because the trust lays out the requirements of how the power of appointment will be disposed of. A lot of times it says that there must be an explicit reference to this very provision of the trust. There might be particular language that is required.
Counsel, I haven't seen the trust document. Is it in the record?
It is, and I believe it's CR 116, Your Honor. So it's there in full. And I unfortunately don't think I have the explicit page number in the record of the trust, but I can tell you.
And we're talking about the RCB Inter Vivos Trust.
That's correct, Your Honor.
Okay, that's all right. If it's in there, it's in there.
And actually, what I can tell you, Your Honor, is that the trust starts on 116, and the provisions talking about the testimony power of appointment created under the trust is on page 38 of the trust. And I'm happy to provide a letter to the court afterwards specifically.
No, that's fine.
Record. But the point I was making was that you start with looking at the trust to see the parameters of the power of appointment. And then you certainly have to look at the will. But all you're looking at in the will are the provisions of the will in which one of the parties is alleging demonstrate that the power of appointment was effectuated. That's it. Once you look at that language, you go back to the trust and you say, well, was this fully effectuated? And if so, the trust assets are alternately disposed of. That's it. And so the settlors decided in 2011 when they set this up and created the power of appointment is that they didn't want to include an arbitration clause.
You say that, is there testimony in the record that they didn't want to do that? Or are you arguing that based on the absence of an arbitration provision from the document?
That's a fair point, Your Honor. And it is indeed our position that it is reflected from the absence of it in the trust itself. And I think that some further evidence of it is the fact that one of the settlors, the decedent who we're talking about, executed the will that we're fighting about 5 years later that did include an arbitration provision. But the important part of this point is that the intent of the parties that must be measured is the settlors when they created this trust in 2011. If we are to accept the appellant's position here, we would be suggesting that an irrevocable trust could be amended 5 years after it became irrevocable via a will because it contains an arbitration provision. Let me give you an example. Under the appellant's point, this trust could have contained an express provision that said under no circumstances shall any conflict regarding the exercise of a power of appointment created under this document be decided by arbitration. But because we have this will later executed that purports to exercise the power of appointment, and that contains an arbitration provision, suddenly we can ignore the settlor's intent in the trust document. And so again,
Counsel, hadn't it been the law for long time in Texas, that the settlor or the testator in a will can say, you know, I'm gonna give away that 100 acres that you already own. I'm gonna give you $1 million in my will. You have a choice. You can take the $1 million and let the 100 acres go where I want it to go or not. And you have a choice to make. And why is the provisions in this will, even if there had been a specific prohibition for arbitration, why isn't it the testator's opportunity, right, to say, I'm gonna make you a beneficiary of my will, and any dispute under my will, even including that trust out there that can't be arbitrated, you have to submit to binding arbitration?
I think the specific answer to your question in this context is that because the power of appointment that we are debating is wholly dependent on the trust. If we were talking about a pure will construction case where all we were fighting about is the will in context, we weren't worried about a trust document that it refers to, the answer might be a little different. But the intent here that I think the court has to respect and first look to is the trust itself. But I can also, I think, answer your Honor's question by turning to the other lens that we can view this case through, which is just that this is a will construction case. And so we then get to hit head on the question of whether an arbitration provision in a will is enforceable in the first place. And the first reason, we provided 3 in our briefs why we think that an arbitration provision, or at least this one, is not enforceable. The first one is just a practical application, Your Honors, of the Texas Arbitration Act. We think that appellants have just completely glossed over this, probably intentionally, because they think it's a loser. But a straight application of the Texas Arbitration Act is that it requires a written agreement. And as the appellant seeking to enforce arbitration, Your Honors, they have the burden to establish that a will is actually a written agreement. And thus far, they have provided this court with no authority, even suggesting that a will is a written agreement. They don't have a single case telling this court, or even, again, suggesting or implying. All they have is the Supreme Court's decision in Rochelle, which I appreciate Your Honor providing clarification to. I actually listened to the Supreme Court oral argument, and Justice Heck pronounced it Rachel. So that's what I've been doing. So I'm glad for that correction. But all the appellants have provided this court with is that decision, and are essentially asking this court to do a Control F, find and replace every time that opinion says the word trust, flip it out and include will, and you have your answer. The problem with that is it's of course an oversimplification and reading of the Rochelle case, and it ignores the fundamental differences between a will and a trust. At its core, a trust is an agreement. Because when it is created, assuming we're talking about an inter vivos trust, there's on the one hand a party called the settlor who is contributing property to the trust. And on the other hand, we have a trustee who is accepting that property and agreeing to hold it, manage it, and dispose of it via specific terms that the settlor has provided. So a trust, which is again what was at issue in Rochelle, is no question an agreement when it is created. Now let's compare that to a will, which the Supreme Court in Stewart v. Sedler back in 1971 described as a unilateral instrument. And that is because a will, when it's created, number one, has no effect at all. It can be revoked, it can be amended, it can be changed up until the moment of death. And number two, there is no agreement with anybody, even when it's created and even after the testator has died. Your Honor, a will can be admitted to probate and its terms carried out without a single executor appointed, without administrator appointed. It's called a uniment of title, which I'm sure your honors are aware of. And so fundamentally, the difference between a will and a trust is what removes wills from the purview of Rochelle v. Rights, which appellants are desperate to rely on. But here's another thing that I think is really important on this point, something that we haven't talked about. Texas Civil Practice and Remedies Code 171.003, which is part of the Arbitration Act, requires courts, when they're construing novel issues in arbitration, to construe the statutes to affect its purpose and to make uniform the construction of other states' laws applicable to an arbitration. So courts, when they encounter novel issues, are supposed to look to other jurisdictions that may have encountered that. And I can tell you right now, as of yesterday, I don't think there is a single United States court decision anywhere that has ever held that a arbitration provision in a will is enforceable, absent statutory authority. Conversely, several jurisdictions have addressed this issue and found that arbitration provisions in wills are not enforceable per se. And one particularly analogous and helpful opinion was the Superior Court of New Jersey's decision in Re Estate of Heitman, which is cited in our brief. That was just happened in 2023. It's the most recent appellate opinion that I've been able to find. And the reason it's important is because, like Texas, New Jersey's arbitration statute only requires an agreement, whereas a lot of jurisdictions, like the Federal Arbitration Act, require a contract for arbitration to be enforced.
Counsel, I recall in one of the briefs, I don't remember which one, the discussion of this, and there were three states that went one direction, three states that went the other direction. I don't know if it was actually holding whether or not an arbitration provision was allowable or not allowable in a will. But my recollection is that there were at least three states that said there was no inherent problem with an arbitration provision in a will.
In those three states, Your Honor, which are Florida, Utah, and Nevada, the basis for that is statutory authority, because those legislatures of those states have took it upon themselves to answer the question so that the courts don't have to guess. And so in my recollection of those statutes is that even though they recognize the applicability and enforceability of arbitration provisions and wills, they've actually limited the purview of the scope.
Did the other three states, as a matter of public policy based upon an arbitration statute, say that it is prohibited to do it in a will?
Yes, two of the three states, New Jersey and New York, Your Honor, two of the three that have found that they are not enforceable. On top of New Jersey specifically found that it was unenforceable pursuant to their arbitration act, but they also found separately that permitting arbitration to invade the probate realm would be against public policy. And that's actually the second point I was going to bring up, which is touched on by Mr. Pike, is that what they want to spin this as, the Texas arbitration as applying to everything. And then subsection 0.002 having carved out only a few narrow types of cases that it can apply to. And that is not correct. While the legislature has specified in section 171.002 a few types of cases that arbitration unquestionably does not apply to, that doesn't mean there are other areas that it doesn't. And let me start with actually one of their prime examples. Mr. Pike brought up, family courts have exclusive and continuing jurisdiction of suits affecting the parent-child relationship, SAPSers. And that is correct. If that's the case, how is it that there are these appellate opinions that say that you can arbitrate a SAPSer case? Well, the answer is because the legislature not once but twice has codified statutes in the family code that permits arbitration of specific proceedings. First one is Texas Family Code 6.601, and the second is Family Code 153.0071. That second statute very clearly says that a court can refer a suit affecting a SAPSer to arbitration if the parents agree. The former statute is allows the court to refer a divorce to arbitration. So if appellants are correct and that the general rule is that all cases can be arbitrated and that section 0.002 carves out only a few types of cases that cannot, what they're really saying is that these family code statutes are surplusage. Why would we need them? Because the courts already know that they can refer these types of disputes to arbitration. The answer is that it's not as simple as what Mr. Pike would have this court hold, that actually the default rule is not that all types of cases can be referred to arbitration. And turning specifically to the probate code, unlike the family code, Your Honor, the legislature has never enacted any statute in the probate code, or excuse me, the estates code that grants any type of authority to refer to arbitration. The actual opposite is true, as we argued in our brief section. Estates Code 32.002 specifies that only probate proceedings must be filed and heard in county courts exercising probate jurisdiction. And probate proceedings is also defined to include a number of proceedings, but notably a will construction suit. The phraseology filed and heard is very unique in Texas, across the Texas landscape for statutes. I think it's referred to 3 times in the estates code, and 1 time in the tax code, and 1 time in the water code. What that means is that what it says. Proceedings like will construction suits have to be filed and heard in probate courts.
So it would be your position that if these parties agreed to mediate any dispute involving an estate, to use the example that your opposing counsel used, whether or not this was a holographic will, a valid holographic will, and they agreed to mediate that question, you couldn't do that?
That's an interesting question, because then you are turning that agreement into an actual contract. I still think the public policy response would say that unfortunately, no. The legislature has restricted the purview of who gets to decide will construction cases, in which frankly emphasizes the point that we.
So all the settlements that have been made in probate proceedings for the last 150 years, through mediation, are invalid?
No, Your Honor. And the reason being is that those are agreements that are outside the probate proceeding itself. They're just settling the dispute. Now, are you contemplating an arbitration provision in that kind of proceeding?
I hadn't thought about it, but I'm just talking about you've argued that it's filed and heard, and it seems like I'm trying to figure out where these dovetail, because they're both alternative dispute resolution techniques.
No doubt.
And it would seem, if I understand the appellant's arguments, that could be done, whether it's mediation or arbitration. But what I hear you saying is that you can't mediate because you're turning it over to a mediator, because as an appellant was arguing, once you get an agreement, you reach a resolution, whether it was through mediation or arbitration, you come back to court and you enforce that through the legal mechanism.
I understand. And to be very clear, big difference between, obviously, we think, between mediation and arbitration. I think the state's code actually includes express provisions on mediation. The distinction is that you are working to settle the case within the confines of the proper court with proper jurisdiction. Arbitration would be actually removing all the decision-making to a court that has this legislature, or excuse me, to a decision maker that the court legislature has not said can hold that. I know I'm running out of time, so I want to quickly address some other points that I think your honors expressed interest in. The case that appellants cite for the super jurisdiction of probate courts, Texas, the Supreme Court, and In Re Centerpoint Energy Houston Electric. I think they cited for the proposition that, well, there's nothing special about probate court jurisdiction. That's not what that case said at all. We do not contest the holding of that court whatsoever, because it's not relevant. If you actually dive into the actual holding of that court, that case involved a claim that a probate court only had concurrent jurisdiction with the district court over. And we are not here saying that a claim that a probate court only has concurrent jurisdiction can't be arbitrated, because the estates code makes very clear that such a claim can be filed in probate court, can be filed in district court. And so that's outside the purview of what we're talking about. And so the actual quote from that case is that probate court jurisdiction over the plaintiff's claims is no greater than district court jurisdiction would be. And so it wasn't this just general rule, probate court jurisdiction is never greater than a district court, because again, under 3.002 of the Texas Estates Code, the legislature has defined very clearly the specific types of cases that must be filed and heard in probate court. The last point I want to touch on, Your Honor, goes to this idea of the idea that we are not attempting to seek benefits under the will, and that of course goes to the direct benefits estoppel under the Rochelle case. There seems to be a misunderstanding from the appellants as to how this case was initiated. The appellants are my clients' aunts and uncles, and are the trustees of their descendants' trust that receive by default under the bypass trust and the survivor's trust. After the decedent's death, they subjectively determined, hey, this will fully carries out the power of appointment. So guess what? Our trusts get it all. You get nothing. And so that subjective determination, which was never blessed by any court, is what has led to this. And so while it is true that we don't want the court, or we don't need the will, we don't want the will, because they've made this subjective determination, we basically have to go and file a lawsuit to determine a negative, that this will does not do what they say it does. They have put us in this position because of their frankly breaches of fiduciary duty by making these subjective determinations. And the inquiry under Rochelle, and I see that I'm out of time, so I will just briefly conclude, is whether we are attempting to enforce a right that would not exist without the will. It is very clear that our rights exist under the trust, not under the will. Nothing about the will can increase our rights. It is all under the trust. And for that reason, direct benefits estoppel does not apply. And so we think that the court has numerous bases to determine that the trial court's decision was correct. Thank you, Your Honor. Unless there's no other questions.
Thank you, counsel. You may proceed when ready, Counselor.
Thank you, Chief Justice. To make it easy on everybody, the trust is easily accessible to the court in our appendix to our opening brief, our appellate's brief. And the trust in page 38 of the trust, which I believe is also at page 105 of the record. Actually, this trust and will are in the record so many times it's nauseating. Specifically, it is an irrevocable trust after the death of both settlers, but a trust can be amendable in certain ways. This trust specifically provided for a way of amendment. That's what a power of appointment is. The trust says who are the beneficiaries, but I'm going to give a person, in this case, the surviving settler, Mr. Harris Sr., the ability to exercise the power of appointment. And what does it say in that regard? Section 15.4a, that the power of appointment may be exercised solely by language in the duly probated will of the donee. In other words, Mr. Harris had to draft the will if he wanted to exercise the power of attorney. He had to probate it together. So it is not Mr. Harris Sr. attempting to rewrite a trust. He's trying to exercise the power that he was explicitly given by the vehicle giver. And if my opponent is correct that the only assets are in the trust, and we're really talking about dividing the trust, then the only reason to have drafted the will is to exercise the power of appointment. And that means that the testator was clearly thinking, if there's a dispute over this power of appointment, I want to determine how that dispute is resolved. And he chose arbitration. That doesn't violate the terms of the original trust. It's in total compliance with it. We'd be having a totally different argument if that was the case. So if we are, as we always are with the will, trying to determine what the testator's intent is, that makes very crystal clear that this testator, by drafting this will, exercising his power of appointment, including arbitration, wanted any dispute concerning that power of appointment arbitrated. The argument here that a will is not an agreement kind of gets back to really an argument that's not a contract. Says, well, a trust is a contract and a will isn't. And as we've gone through the case law, that's not the Texas Arbitration Act, and it's not a requirement of the Texas Supreme Court. A will is more akin to a unilateral contract. We don't tend to think of that very much. That's like first semester law school stuff, because unilateral contracts are fairly unusual. I happen to just cite a colloquial example in my will that just someone made a public offer of an award, and in doing that actually had an arbitration clause. So I'm going to offer you a reward, but if you have a dispute about it, there's an arbitration clause. It was resolved by arbitration. But I cite real case law, the Vannigan's case, 302 Southwest 3rd, 299 Texas Supreme Court, that is a unilateral contract occurs when someone says, I'm going to give you benefits, and they agree to accept the benefits. And a will is exactly like that. There is nothing about a will that requires the beneficiary to accept the benefits of the will. They can, in fact, in compliance with the Texas Estates Code, disclaim those benefits. So is there something in the public policy of the state of Texas that requires that we not allow arbitration of will disputes? I don't think there's anything in the statute that's done that, and we've parsed that. And the cases that have found that in other states are saying it's their state's policy that would violate their provisions. And I can't speak for New York or New Jersey, but the New Jersey case said, well, because of our unique statutory scheme, and I think a careful examination of the Estates Code, which never mentions arbitration one way or the other, does not do violence to or rewrite the Texas Arbitration Act. So the reason that the Texas Estates Code doesn't say anything about arbitration is we have a clear statement in the Texas Arbitration Act about what can be arbitrated, what can't be arbitrated, and it wasn't necessary to say anything more. The legislature has spoken. The Texas Supreme Court has made clear that when there is a relationship and there's an agreement concerning that relationship that requires arbitration, and the dispute is within the terms of that agreement, which it is here, then arbitration is required. So we ask that the court reverse and order that this matter be referred to arbitration by the district and by the county. Thank you.
Question. Thank you, counsel. This case is submitted. Y'all are excused. Again, you're welcome to stick around and watch the third case. And we're going to take about a 5-minute break.